Greetings everyone, I am Sayantani Dey in my penultimate year of BA-LLB, and the topic which caught my attention in past few days is a recent Supreme Court judgment on the property rights of daughters. The Supreme Court in recent years has always taken a gender-neutral stand when it came to division of property between daughters and sons. January 2022 witnessed a pivotal judgment on the right of daughter. In one case of Arunachala Gounder versus Ponnuswamy, the Supreme Court, while dismissing the appeal against the trial court judgment, held that a daughter of a male Hindu dying intestate would be entitled to inherit the male's self-acquired property or property obtained in the partition of a coparcenary or a family property. Both the trial court and the High Court found that the daughter was not eligible to inherit such property. The Supreme Court was encountered with two questions: whether the late Marappa Gounder's sole surviving daughter Kupayammal would inherit the self-acquired property by inheritance, or it would devolve by survivorship upon the father dying intestate prior to the enactment of Hindu Succession Act of 56. Another question was regarding the order of succession after the death of such daughter, which was after the enactment of Hindu Succession Act 1956. The court held that this right is well recognized, not only under the old customary Hindu law, but also under various judicial pronouncements. Therefore, the property was rightly inherited to Kupayammal. As far as the question regarding the order of succession is concerned, the court held that Section 15 and 16 of Indian Succession Act clearly defines what will be the order of the succession after the death of a female. The court held that if a female Hindu dies intestate without leaving any child, then the property inherited by her from a father or mother would go to the heirs of her father, whereas property inherited from a husband or father-in-law would go to the heirs of the husband. In case a female Hindu dies leaving behind her husband or any child or issue, then Section 15, subsection 1, subclause A comes into operation, and the properties left behind, including the properties which she inherited from her parents, would devolve simultaneously upon her husband and her issues as provided in the section. What differentiates this extremely commendable judgment from ones delivered earlier is that Supreme Court had in August 2020 ruled that daughters will have inheritance right equal to those of sons in the property of fathers, grandfathers and great-grandfathers, right from the codification of Hindu laws in 1956. This learned judgment took the daughter's right to the pre-1956 period when male primacy were in vogue pertaining to inheritance of properties. While in para 63 of the judgment, the court observed that in the 174th Law Commission report on property right of women, while proposing reforms under Hindu law, the Commission has observed that the Mitakshara law recognized inheritance by succession but only to the property separately owned by an individual, male or female. Females are included as heirs in this kind of property by Mitakshara law. Before the Amendment Act of 1929, Bengal, Banaras and Mithila sub-school of Mitakshara recognized 5 female relations as being entitled to inherit: widow, daughter, mother, grandmother and paternal great-grandmother. The Madras sub-school recognized heritable capacity of a large number of female heirs. Daughters and sisters and heirs were expressly named in heirs of Hindu Laws of Inheritance Amendment Act 1929. The son's daughter and the daughter's daughter ranked as bandhus in Bombay and Madras. The Bombay school, which is most liberal to women, recognized a number of other female heirs, including a half-sister, father's sister, women married into families such as stepmother, son's widow, brother's widow, and also many other females classified as bandhus. The Apex Court made it manifestly clear that daughters' right to inherit self-acquired property of father dying intestate is recognized under customary law. The Supreme Court, in time and time again, given progressive decision and has made devolution of property a more equitable arrangement. The judgment corrects an obvious anomaly in interpretation of crucial 2005 amendment of the 1956 Act. The question whether the coparcenary right of daughters come into effect only if the father, through whom they claim that right, was alive on the day the amendment came into force. The Apex Court has now categorically ruled that the daughter's right flows from their birth and not by any other factor such as existence of their fathers. The court's reasoning is unexceptionable. First, it locates the origin of coparcenary rights in one's birth. Second, it finds that there is no necessity for a predecessor, coparcenary, to be alive for one to acquire that status, as what is relevant is birth within the degrees of succession to which it extends. In that sense, the legislation, even though it came into effect on a prescribed date, is retroactive in its application, as it is linked to birth, an antecedent event. It also underscores that the legislation makes it clear that the daughter's rights are the same as that of a son, and as she has been a son at the time of the birth. The main scheme of Hindu Succession Act was to establish a complete equality between male and female with regard to property rights, and the right of a female were declared absolute, completely abolishing all notions of limited estate. Section 14 was to remedy the limitation of a Hindu woman who could not claim an absolute interest in the properties inherited by her, but only had a life interest in the estate so inherited. Whereas Section 15 of the Hindu Succession Act goes to show that the property of Hindu females dying intestate is to devolve on her own heirs as per the enumerated list in the subsection. Section 15(2) carves out exceptions to this, only with regards to the property acquired through inheritance, and is confined to the property inherited by a Hindu female. The basic aim of Section 15 subclause 2 is to ensure that inherited property of a female Hindu dying issueless and intestate goes back to the source. The source from which she inherits the property is always important, and that would govern the situation. Otherwise, persons who are not even remotely related to the person who originally held the property would acquire rights to inherit that property. That would defeat the intent and purpose of subsection 2 of section 15, which gives a special pattern of succession. If a female Hindu dies intestate and childless, the property inherited from her father or mother would go to the heirs of her father, whereas the property inherited from her husband or father-in-law would go to the heirs of her husband. If a female Hindu dies leaving behind her husband or any issues, then section 15, subsection 1, subclause A would come into operation, and the properties left behind, including the properties which she inherited from her parents, would devolve simultaneously upon her husband and her issues, as provided in section 15(1)A of HSA. Thank you for listening to me so closely and carefully. I appreciate the concentration. That would be all from my side. Thank you and have a great day ahead.